The next matter before us this morning is Lori S. Sandel versus David Choma, and I apologize if I have mispronounced his name. I hope that you will correct me. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I can give you a clock, I can give you a price of passage of time. But we have read the briefs for you, see who you are.
Good morning. May it please the court, my name is John Donor. I represent the appellant David Choma in this matter. I would like to reserve 5 minutes, although I don't think I'm going to use 10 on this part of the argument. This is a very simple matter. It is a mathematical issue. The calculation is of support. The court has seen this case before. The parties have unfortunately had to come up twice before, and the case was twice remanded. The issue is fairly simple. At a point in time, Lori Sandel was ordered to pay child support. At that time, she was an administrator, a school administrator, and earning in the $90,000 to $97,000 range. Child support was ordered. Subsequent to that, she left her position and she became a hostess at a local restaurant. Since that time, she did get back into the school. She was a teacher, then very quickly a assistant principal, and then a principal. And correspondingly, her income went up. And during that same period of time, and we are talking a period of about 2012 to 2016, during that same period of time, my client incurred medical expenses for the children. There has been, and it's an understatement to say, an inability of these people to cooperate reasonably to try to work these issues out. Consequently, a motion was filed to reset child support to offset some of the overpayment that the mother had been making. I neglected to say that there is a overpayment created when the older child was emancipated, and the court did not modify the child support right away, and so she continued to pay the higher amount of support.
To the tune of 12 grand.
Yes, to the tune of 12 grand. It went on for some time, and
The entry speaks of 16,000, doesn't it?
it does. At the hearing, it was the CSEA had calculated the $12,000 figure as of August of 2014. The motion was filed in January of 2015 by my client to modify support. And the hearing was not held until October of 2015. So
The parties agree on a 16,166 figure?
they agreed on Exhibit H, which has both figures in, and the $16,000 figure was in there, projecting out to the date of the hearing the overpayment. The intervening event, though, is child support was modified. So from January 2015 until the hearing, there was not an overpayment. In fact, there was an underpayment based upon the child support calculation. There's no disagreement on the medical bill portion of that, and the parties stipulated to that. And the parties also agreed that because the other child, the second child of theirs, would be emancipated in May of 2016, that we would project out until his expected emancipation date and credit that against mother's support. So in total, if the court uses the projected $16,000 figure and then goes back and, as it did, and changes the child support, the $16,000 figure then becomes inaccurate. It is $12,000. It should be the starting figure used by Judge Quinn and the magistrate below. It is an oversight that if the court looks at Exhibit H in the record, again that was stipulated, it clearly says in the first line, CSE overpayment as of 8/14/2014 is $12,587.37. Either way that this matter is argued, well, I guess the way that the $12,587 and make his modifications to support at that time, then you're going to come up with about a $4,000 difference. And I did the math in the brief of what I believe the actual figure of overpayment remaining to Ms. Sandel is. My client agrees that in fact there is an overpayment that she still has credited to her, not just the size that the trial court had set, but about $4,000 less.
Thank you, Counsel.
May it please the court, my name is Kevin Sandel, representing Lori Sandel. There is no error. There is no mathematical error. Judge Quinn is correct, was correct in his ruling and his math regarding the overpayment, even with the medical expenses credited back to Mr. Choma. That is my client's position. Even if there is an error, alternatively, so even if there is an error, it is not this, it does not rise to the level of abuse of discretion for that this honorable court to substitute their ruling or their math for Judge Quinn's.
Well, if there's an error, if in the facts, it's not the same as if someone utilized their discretion to make a decision. Wouldn't it be incumbent upon us to send it back for the trial court to revisit the issue instead of indicating that an error has been in math or facts has been identified, but it was not an abuse of discretion? It doesn't seem to me you can be discretionary, you utilize your discretion if you are operating on a misconception of fact.
This court has that option, obviously. I would, again, our initial position is that there is no error to begin with.
And
However, the court had all of these documents and made the decision that the court made regarding the overpayment at the $6,523.20 level. So I'm not here to presume that the court made an error. I don't believe the court did make an error. If this court chooses to remand back to review it again, review their decision again to, obviously that's in your discretion to do so.
To the best of your understanding, or let me rephrase that, it does not sound to me from reading the briefs that you had no disagreement with any of the numbers.
Correct.
So I'm going to ask not about the 12,000 figure, but about the 16,000 figure. To the best of your understanding, that projected figure by CSEA, did it take into account a modified child support that had already been modified, or did it not take into account?
To the best of my knowledge, it did not. I would like to mention one thing. The overpayment was not created by the oldest child becoming emancipated. The overpayment was created by appellants, objections, motions, and appeals. So it was hardly an average overpayment based on a child being emancipated.
Would that affect the numerical calculations? I gleaned that from your brief, but would that have any effect on the numerical calculations? The reason why the overpayment ended up being so large?
No. I mean, the reasoning is what the reasoning is. Again, not to repeat what I was saying before, but Our position, my client's position is Judge Quinn's numbers are correct, Judge Quinn's calculations are correct, and we're here to reinforce that. Thank you.
Council, there are 5 minutes.
If it pleases the court, I will conclude without any further comments. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both sides as well as posted on the House Supreme Court website. You can access that through the 9th District Court of